in the workplace presentation that we're delighted to be sponsoring. My name is Aidan McGeary. I'm Managing Director of Blue Machinery Central. We're based in northwest of England and working with in partnership with other Blue Group network. We specialise in supplying capital equipment for the handling and processing and excavating materials to a wide range of industrial sectors, including skip waste, waste management and recycling on a national level, with a strong focus on the provision of after-sales support in the form of spare parts, breakdown response and contracted servicing packages, using technologies and innovation to ensure uptime of the equipment. As the business has developed, Blue Machinery Central is 30 years in business this year. We appreciate and recognise the importance of compliance and adhering to health and safety guidelines as a priority. It is especially due to the nature of the industries we serve and the often dangerous and hostile environments our team can be exposed to daily that we are delighted to attend and support UROC with this webinar, an initiative focused on raising the profile of this topic to their membership and the wider sector. The single biggest driver behind our focus on health and safety is the well-being of any individual and their families, whether they be one of our own team or that of one of our customers, suppliers, or anyone else associated with the sites and businesses we serve. We also acknowledge the consequences from a financial, resource and legal perspective of any failure to adhere or meet the guidelines or legal requirements, and welcome any advice on how we can ensure best compliance practices, both from a legal and a practical point of view. We wish the team at UROC, Lucy and Matthew, who are speaking today, presenting, well for this webinar, and look forward to learning what we can to improve our performance and develop the health and safety culture within our own business and, hopefully the wider industry. So I'll just hand over to Jenny now just to show a short video just to give you a bit more insight into what we do, and then we'll be on with the speakers. So thank you, Jenny.
Excellent. Thank you, Aidan. Just as a side note, we are recording this session. It's going to be available to download after we've concluded on the Blue website as well as the UROC website. I've not received any objections to it being recorded, and the privacy policy note is at the top. I'm going to dismiss that now unless there's any objections, and we'll have a little look at the Blue video. Let's make this big. Here we go.
Blue is a market-leading supplier of materials processing equipment for quarrying and demolition, scrap, recycling, ports and energy. Throughout the UK, we deliver quality machinery and an unrivaled service. With 10 key locations and 5 established regional offices, we offer total solutions from single equipment supply to installation, training and ongoing support. Blue's comprehensive portfolio of the world's leading OEM brands, combined with our 3-step nationwide support service, builds long-lasting relationships with our customers. Our commitment goes by delivering unbeatable support services throughout a machine's lifetime, resulting in optimal functionality, uptime, and longevity. This unique range of value-added services is forging new standards within the industry. Our vast experience, knowledge, and expertise is helping UK business operations to expand like never before. As we drive forward, we do so with our customers in the forefront of our minds. Blue. Waste nothing. Gain everything.
Video. Thank you for that, Blue. Right, so if you've all got your microphones off, I'm going to hand over now to Lucy. Lucy Wright is a barrister at Lincoln House Chambers who practices in criminal regulatory work with a particular specialism in health and safety law. In recent years, she's prosecuted and defended in cases arising out of serious incidents at work that have resulted in the death or catastrophic injury to employees. Much of her work has involved companies who operate in the waste and recycling sector. I'm absolutely delighted that you're joining us and giving insights into your cases today, Lucy. I will now swap over to the screen, if everybody can see that. There's Lucy, and away you go when you're ready.
Thank you, Jenny. Well, if anyone loses the ability to hear me throughout the course of the presentation, if you maybe just press the hand up button, and then if there's an error at my end, I can be alerted to it. Thank you, Jenny, for the introduction. That's right. My name is Lucy Wright. I'm a barrister, as Jenny says, at Lincoln House Chambers in Manchester, and specialise in health and safety, but criminal regulatory work generally. And I suppose it started as a quirk, but now I have really in the past couple of years been focused and involved in cases that are connected to the waste and recycling industries, metal, paper, wood, across the board really. And so I hoped today through this presentation that I'm going to take through really as a broad overview the legal requirements and legal framework that apply to health and safety in the workplace that are industry specific, but also more generally. And then to go a little bit through the regulations that apply and really what happens when things go wrong in respect of the sentences or the types of sentences that might follow for both a company and individuals who are convicted or enter pleas of guilty, they having been prosecuted for health and safety offences. So that's really the shape of the presentation that I hope to deliver. It should be about 40 minutes. I think then we're going to have the opportunity for some questions, Jenny, is that right? And then perhaps a comfort break before we start the next presentation. So with that, I'll start. You can see then that the first slide is really, what are the legal requirements in respect to health and safety in the workplace? Well, the answer is really this. Or I should have said, maybe the slide should say, what law applies to health and safety in the workplace? And the answer is that there is both statutory law that applies and regulations that are in place. They are legally enforced and they apply to industries who operate across this sector. So we'll take them in turn, but I should say and start this presentation with this warning really, that this is just an overview or an introduction, I hope, that you'll find helpful, setting out the law, but it's not in any way designed to be comprehensive and to cover each and every aspect that might apply to the industry that you work in. And so whilst of course I hope that there is help, that it would be, or that it's in terms of reliance on the information I'm giving, it doesn't or shouldn't ever supersede professional health and safety advice that you are exposed to and you're given. So if we can have the next slide, please, Jenny. Let's first then talk about the legal framework. Well, the principal law that applies in respect of health and safety in the workplace is the Health and Safety at Work Act. And that provides a series of offences that can be committed by both companies and individuals if there is an accident at work or if someone is exposed to the risk of an accident at work. There is also, and number one, manslaughter. There's no law, it's a common law provision. Sounds a very boring legal topic or concept, but really it's this. Manslaughter has both corporate and gross negligence manslaughter aspects. And so if it is that on your site or on a site that you have got contractors going to, or is a site operated by you but run by contractors, then there is always the possibility, were there to be a fatality on that site, that both the company and an individual could be responsible in law for that death. It need not be an employee who has tragically lost a life. It could be a contractor or a visitor to site who is covered by the provisions. And really, a corporate manslaughter is likely to be prosecuted by the Crown Prosecution Service following a fatality where that death has been caused by the way in which the activities of that company were being managed or organised by those who are in the senior management. Now, senior management will, of course, differ from site to site, industry to industry, and company to company. It's always a decision as from the prosecution as to who falls within senior management. But it's really any individual within an organisation who has real decision-making power. So certainly those that have manager in the title, but those who are perhaps line managing a sufficient number of employees, or who are able to make decisions that affect the corporate policy or the economic policy of the company, will also be caught by that definition. And it will concentrate really on the way in which the company was conducting itself, and whether any shortcomings were so bad and that the breach of the duty of care that they owed to those on their site was gross. And gross has a legal definition that I'll come to in a little bit, but it's really an offence that a company will be prosecuted for where there's been a death and that there are failings in the health and safety and the way in which health and safety is managed. It need not be by an individual who is lax in their health and safety. It can be what's called the aggregate acts of all of those who occupy positions of senior management. So taken together, have the management acted in a way that fell so short of the duty of care that they owed that they have been grossly negligent. And so that's corporate manslaughter. I'm going to interpose and pepper in examples that I've been involved in where there have been prosecutions for corporate manslaughter and gross negligence manslaughter and other offences, so you can understand the type of scenario where people might be prosecuted. So I have a case at the moment, it's still to be tried, but the company are being prosecuted for the corporate manslaughter of an employee who was put in the bucket of a telehandler working at height without really any proper safety features in place at all, breached every probably conceivable aspect as to working at height regulations. And that employee fell out of the telehandler and sadly died. And in consequence of which the company are being prosecuted then for the corporate manslaughter. And as I said at the start of this slide, it need not be an employee who's died where the company is at risk of being prosecuted. I was involved in another case where it was a contractor that had died having fallen off scaffolding, and the company were prosecuted for his corporate manslaughter. So as an overview, really, it is an offence that can attach. It attaches to the company, but it focuses on the acts of individuals. And so beyond corporate manslaughter, of course, if it is that health and safety is being particularly badly managed and that there is a particular individual who is responsible for that mismanagement, then there could also be, and I say could also because very often there is prosecutions against both the company and individuals at the same time as part of the same trial, and for a range of different offences. And so if it is that there has been an individual who it can be said by the prosecution has fallen short in their responsibilities, then there may well be a prosecution for gross negligence manslaughter. It's usually a director, but it would be unwise to lull yourself, or if you occupy a senior management role, or if you are a director of a company, to consider that the actions of those below you are irrelevant. That would be wrong. Very recently, I was involved in a prosecution for manslaughters of a company that was involved in the production of liquefied pig feed. 2 employees went into the back of a road tanker to clean it out. It was a confined space. They had no breathing apparatus. There was no rescue plan in place. And sadly, both the first employee and the employee that went to rescue him were overcome and died. Now, in that case, not only was the director prosecuted for the gross negligence manslaughter, but so too was the transport manager. And even on the basis that the transport manager was answerable to the senior manager, it did not prevent there being a prosecution against him for the gross negligence manslaughter. So it's certainly something to consider in terms of the range of individuals within any organisation who could be liable for prosecution when there is a fatality on site. I'm not going to give any of you, I'm sure you're sat there thinking, thank goodness for that. I'm not going to go into a explanation of the law of gross negligence manslaughter. It could take the entire afternoon, and I'm not sure anybody would thank me for it. But it's not dissimilar to corporate manslaughter, but it focuses on the acts of an individual, on the individual's breach and what that individual has done, and whether or not their acts or omissions are such that they've caused the death of the employee that's died. And so really, that is the overview in respect to prosecutions for manslaughter. I've then listed there that there is also the legal framework that applies, sections 2 and section 3 of the Health and Safety at Work Act. They are offences, they've set them out there for you as to the duty that they provide in law, but it's really the duty of an employer to keep their workforce safe and to keep those who are visitors to site safe. So contractors, visitors, or people who are perhaps even off duty or who have been employees, former employees who are back visiting sites, anybody that is having access, you need to make sure that you are conducting your business in such a way that it is reasonably practicable to keep people safe and to not expose them to risk. It's a very, very broad offence. It can cover everything from improperly guarded machinery to poor traffic management on site, down to the specifics of exposing people to the collapse of walls or buildings. It's a very, very broad offence, and it requires caution. It requires real consideration as to risks that might arise on your site because of the processing or the storage or the transport of material, just by way of example. I'm going to come on to discuss a bit later in the presentation an example of a prosecution under section 3 of the Health and Safety at Work Act that I'm involved in currently, where there is a really, really broad range of risks that are being alleged, just to assist really in explaining, to setting out that often these prosecutions can be vast in terms of the requirements that they are looking at or the failures that they're looking at. And so if we can have the next slide, please, Jenny. Here, this is section 37 of the Health and Safety at Work Act. And in the same way that there are legal frameworks that apply to companies, there are legal provisions that apply to individuals. As with gross negligence manslaughter, the less serious offence as an individual that you might be prosecuted for is section 37 of the Health and Safety at Work Act. And reality, it's this, that if the company has exposed or an employee or a visitor site has been exposed to risk, and a member of the senior management within that company has consented to, connived, or has been negligent in allowing that breach to occur, then they can be prosecuted. Now, consent, connivance, or neglect, again, total legal geek terms, it really means that you, as that senior manager, have agreed to a practice taking place that exposes someone to risk, or you've been willfully blind. That's really what connivance means. You've been willfully blind to it happening on your site, either because it's too difficult to force employees to act differently, or you suspect it's going on, but really it's easy not to get involved. If the prosecution can prove anything like that, then you expose yourself to the risk of a prosecution under section 37. And neglect, self-evident. If you have been neglectful in making sure you understand the types of practices and processes that your workforce are engaging themselves in, then again, you too may be prosecuted for a section 37 offence. It need not result in death. It could be an injury that is sustained by an individual, and it can be anything from a fairly minor injury to a really quite serious injury that is sustained to have a prosecution under those provisions of the Act. And so really, my headline in respect of a section 37 offence, much like for gross negligence manslaughter, is that proceed with caution, because not only is the range of people that are potentially captured by that section of the offence quite broad, but it's also for a wide range of activities that might be covered by it. I was involved in a case in January of last year that was the prosecutions that arose out of an explosion at Bosley Mill in Cheshire. That was a wood recycling mill and a wood recycling facility. The mill exploded. It was grinding wood down into dust, and as many of you who are in that industry might be aware, wood dust is extremely explosive, and when ignited results in absolute catastrophic explosion. And it razed this mill to the ground, and in the course of it, sadly, 4 people died. The company were prosecuted for the corporate manslaughter, the directors for the gross negligence manslaughter. But then 2 of the mill managers were caught up in the prosecution and were joined at trial to be prosecuted under Section 37 of the Health and Safety at Work Act. Now, those managers were fairly low down the chain of management control. One was a mill manager who was, in fact, just by way of example, being paid less than many of the employees in the mill who were on overtime, flexi-time contracts. But because he had manager in his title, it mattered not really in reality the power that he said he exercised. The prosecution decided he was a manager, and so he was prosecuted initially for that offence. I would say fortunately, because he was my client, but he was, in fact, there was verdicts of not guilty returned in respect of him. But it's just really goes to show and cause to show that there is no security necessarily for people who are managers, but not necessarily at the top of the management chain. You need to make sure that you are compliant with the provisions and that you are neither consenting, conniving, or being neglectful in respect of breaches of health and safety policy and the regulations and the law. The final offence, and I've not included it in the slide because I didn't want to overburden everybody, but is an offence under Section 7. It's an offence against employees and I think someone's microphone might have just I don't know whether everyone can just mute. I don't mind if it's a question. I'm happy to take a question. If it's an accident, I'll just move on. But Section 7. So we can have prosecutions against a company, against managers as individuals, but also against employees for failing to take responsible care of each other as employees. And so really, the Health and Safety at Work Act is comprehensive. You need to pay attention to the law, understand the responsibilities that apply depending on your role or place in the organisation. There needs to be training. People need to understand through training what their responsibilities are, because in law, it's not going to be good enough, and it won't avoid a prosecution to say, I didn't realise that was my job. I didn't realise I was required to make sure that that didn't happen. It's ignorance is not a defence. That's the famous legal tagline. It's not a defence, and so education is really important within any organisation. And no doubt, very, very many of you will have in-house health and safety specialists and health and safety teams. You may have recourse to specialist health and safety advice. And from my point of view, from the person who has to try and assist and help when there has been something that's gone wrong, the better engagement that you can have and to show with those types of individuals, then all the better. To avoid the accidents in the first place, but also to seek to ensure that if there is to be a prosecution, that there can be a damage limitation exercise. So with that, can I have the next slide, please, Jenny? Thank you. So in fact, there you go, look, setting up, that's the remainder, Section 37. I think the slides are going to be made available, so all of this is going to be there for you. And again, if anyone has any questions in relation to any of this narrative, I'm more than happy to take them at the end. But if we can have the next slide as well, then that would be great. So not only is there law that applies in terms of Health and Safety at Work Act, there are also regulations that apply. So no doubt many of you will be familiar with the regulations that apply to your industry. There are a wide range or wide variety of regs that apply to those who operate in the waste and recycling industry. It will differ depending on what you do, what material you process, as to what regulations apply. But really, there is a really broad range of issues and considerations that need to be given. The reason that's important, I should say, is this, that you can be prosecuted for a breach of the regulations as well as being prosecuted for breach of the Health and Safety at Work Act. Often, regulatory breaches are instituted where there has been less serious injury, but not always. And breaches of the regulations are very, very often used by the prosecution in more serious cases to say to the jury, you can look at this operator or this company or as this individual as being somebody who is disinclined to take health and safety seriously, because they have not only breached the duty to keep their employees safe, but they have breached these regulations, and that demonstrates to you their attitude. And so it's very, very important that you are compliant with the regulations, not only to avoid prosecution, but also to make sure that your reputation is one that is as good as it can be. So I suppose, and having thought about it, there are so many different types of regulations conceivably that could be covered, I suppose, under the waste and recycling industry. But it seems to me that the three most regularly prosecuted regulations that apply to your industries are the provision and use of work equipment regulations, lifting operations and lifting equipment regulations, and working at height regulations. That is not an exclusive list. It's just perhaps the three that I can think of that are most likely to apply. Now, the provision and use of work equipment regs, it may have been referred to the pure regs, but that really will apply to any machinery that you are operating on site, that your employees or contractors have access to, and it governs the way in which you are required to operate that machine to keep it safe. And so it will deal with things like guarding, making sure you've got proper guarding, that your interlocks are working, that you've got working isolation mechanisms, and you've got captive keys and things like that in place that are going to work. And lifting operations and lifting equipment regs, that's the LOLA regs. It applies to lifting equipment. It's obvious. It's there in the title, and at working at height. I accept that at first blush, working at height regs, we might think, well, we don't work on roofs because we're recyclers, but very many of you will have machinery that goes to height, that you've got cranes with arms that might require repair when you've got employees going into the tops of hoppers that are meters off the ground, things like that. It means that these regulations apply, and so they're important. Could I have the next slide, Jenny, please? And so really, in terms of the regulations, you need to take advice. You need to take advice as to what regulations apply to you. And the best people to do that are your health and safety teams, or get external health and safety advice. Because as I said before, to say, well, we didn't necessarily realise that those regulations apply, unfortunately, is not going to provide any safety net or bar to you being prosecuted. And the regulations are simple to understand. They are set out what is the duty upon you and the requirements on you. I'm going to, in a minute, after we've done the next couple of slides, do some case examples with you. One of those that I'm going to talk about is a prosecution that was under the pure regs in terms of equipment. And so hopefully that will just set out, by way of example, the kind of things that you need to think about in respect of a regulations prosecution. But just before we get to that, the last thing really that's to consider in respect of what applies to me, what applies to the company in the way that you're conducting your business, is industry-specific guidance. Now, all of you, I'm sure, will be familiar with this, and it requires probably no introduction. None of it, or none of this presentation, is meant in any way to be patronising. It's just setting out the obvious things. The HSE is it's a regulator. Yes, they're going to come onto site, probably at the least opportune moment, asking you questions when you've really got so much other things that you need to be concentrating on. But engagement with them is really important. And beyond that, they are really helpful. And there is a wealth of information that you can benefit from by looking at this guidance. They publish industry-specific guidance that is really valuable in my view, in terms of helping you to identify the risks that may and do arise in respect of your industry and how those risks must be managed. It's helpful because these documents are a single source of information. They come as a booklet. They're PDF downloadable from the HSE website. All you need to do is to type in in the search section of the where it says resources, the type of industry that you're involved in. If you put in paper, it will come up with the relevant guidance. If you put in scrap, it comes up with the relevant guidance. And those documents, I've put the link there to two, just by way of example, if there is interest, and you can click on them and have a look later. But they are really single documents that set out the law, so what we've spoken about at the start of this presentation, the regulations that I touched on, but it also sets out the ACOPs that may apply to certain processing, different processing systems that you have on site. And really the ACOPs are the recommended methods that the HSE have approved in order to comply with the law and the regulations in respect of your industry. In essence, it's basically a how-to guide that is really clear, in my view, setting out what risk assessments you need in place, where you really need to have a permit to work system, where you need safe systems to work and safe operating procedures that need to be in place to be trained out, to be available for your employees. And it's all there. And I can't really emphasize enough as a resource that those are really simple, straightforward guides available to you. If you have health and safety assistance internally or externally, and you haven't got those documents, then you should go back and ask for them, because they are really, really handy. And more than that, they are often relied on by the prosecution in proceedings when companies and individuals have fallen short. I know that because I've relied on them when I've been prosecuting to say, well, Mr. X, you know that there is guidance available for the recovered paper industry, and it tells you that baling machines are the single biggest killer. And what reference have you made to that document when deciding your safe systems work? And it's really devastating from a defence perspective if there has been absolutely no reference made to these documents when they are so easily available. So I really can't say enough how it would be useful to have that. I'm going to, in a second, move on to talk about recent prosecutions, but maybe just dealing with it this way, because it's relevant to this slide. When I was saying about prosecuting, I was in a case earlier in this summer that was a paper recycling company who were prosecuted for manslaughter after an employee had climbed a conveyor that was a cardboard conveyor going up to an open-topped hopper into that fed a pneumatic baling machine. Now, there was all sorts of failings in respect of the machinery, of improper guarding and real issues with their isolation and lock-off procedures that I can talk about in a minute. But we relied really heavily in proving that case as against the director, that he had a copy of the relevant HSE guidance document. It was recovered from his office at site. And really, it was very easy then to show that he had failed to put into practice any of the really easy steps that he could have done that were set out in that guidance document. And so it's not a trick for the prosecution to do that. It's a perfectly proper way to put evidence before a court. And so really, from my perspective, get the documents, make sure you've read them, make sure you understand them, but more importantly, make sure you put into place the guidance that's set out and the assistance that's provided in terms of how you should do it and how you can put mitigation measures in place to reduce the risk to your employees and to people on site. So could I have the next slide, please, Jenny? So really then, this is my final slide. Some may be sat there thinking, thank goodness. And it's really this. These are recent cases that I've been involved in, and I just wanted to use them really just as demonstration as to the wide range of ways in which companies and individuals can fall short and end up being prosecuted for health and safety offences. I've tried to keep them relevant to your industries, some of them a bit more or less relevant than others, because I know that not Blue don't necessarily supply machinery to all of these types of industries, but I thought perhaps the most relevant of those examples that I could think of. So the first is the Crown and Wood Treatment Limited. That was the wood recycling case that was the Bosley Mill explosion. And that was a prosecution really that was founded on the failure of the company and of the directors to really take proper notice and proper care in respect of explosive atmospheres and DSEA regulations. So it was dealing with things like lack of a proper cleaning regime, lack of proper control measures, and really the lack of quality control of material going into the machinery that would lead to much more speedy degradation of machinery, lack of proper maintenance, and all of which would create the risk of an explosion. Because if you've got machines that are not working properly, they're overheating, you've got you've got bearings that aren't being greased and looked after properly, so they're getting hotter. You create atmospheres that very quickly, in the scenario or the situation of a wood dust environment, that it becomes explosive. And so that is an example of a case with a totally catastrophic outcome, but where the individual failures of themselves, I'm sure to those working there at the time and those who were prosecuted, didn't necessarily feel that significant, because lack of a cleaning regime, well, you might think it's not as serious as perhaps having totally open and unguarded machinery, but it's a lesson that there are regulations in place for proper reason, and that really that they're there for, they've all got to be complied with, and when they're not, that there can be real issues. The next in that list is Greenfields and others. I know that there's going to be some mention of this case in the next presentation, and it's relevant and important for this because it was a confined spaces prosecution. It dealt with the entering of a pig feed tanker. Now, you may all think, well, we don't have tankers, but tankers are not the only way in which there can be a confined space. You can have confined spaces that the definition of confined space is set out within the regulations. If you have large tanks or storage facilities, if you are storing material, particularly if you're storing very fine material in silos, then you may have a confined space that may require entry. And that is a case that really served to highlight that where there is no proper consideration given to confined spaces, that you will have, you may have a fatality. That was a double fatality, but you expose your employees and others on site to real risks. It requires risk assessments. It requires proper permit to work systems where you've got oversight and somebody in control of what's going on, proper safe operating procedures, and really importantly, proper rescue plans in place. That company had none of those things. They had nothing really by way of health and safety, and it was a disaster waiting to happen. Just dealing then with RCL and Jones, that's the paper case that I just touched on briefly, where the company fell short and the director fell short because an employee was able to gain access to the top of a hopper. The prosecution case was, this was an elevated or movable platform that they deposited into a hopper. There was no guarding. There was a blockage of cardboard across the top of the hopper. An employee climbed the conveyor up to height and, whilst holding onto a rope suspended above the hopper, jumped up and down to free the blockage, and as was always inevitable, fell into the hopper, running in semi-auto, and managed to amputate his own leg, and sadly died working alone and unable to get out of the baling machine. And so again, it was falling short in respect of not having proper risk assessments, not having proper procedures in place for permits to work in respect of locking off and isolating, and not having proper guarding. And so it's really important to think about all of those things. Innocent or seemingly innocuous breaches, like the lack of a guard to stop people climbing in a conveyor, can end up in a really serious consequences. And the final really example there on the statutory offence is, it's a current ongoing case. HMRL is a scrap metal yard in Birmingham who are being prosecuted under Section 2 and 3 of the Health and Safety at Work Act. But it's included because it's an example of really how broad some of these prosecutions can be. The prosecution triggered because of the collapse of a wall that sadly killed 5 employees on site. But the prosecution focuses on such a broad range of risks that range from the lack of segregation between pedestrians and plant on site, to improper guarding, to improper storage of materials, and again, exposure to risk of collapse of walls. And so when I say ask the question, how do they fall short? Sometimes it can be limited and specific, sometimes it can be really broad and really seemingly small things included and wrapped up by the prosecution to show that this is a much bigger failure. And so next slide, please, Jenny. The final part of my presentation, and just keeping an eye on the time because I'm conscious that there are others that follow. Sentencing. Sadly, unfortunately, it's always the way. If you are prosecuted and either enter a plea of guilty or you are convicted by the jury or by the district judge or by the magistrates for a health and safety offence, then there will be a sentence. The court will be concerned with culpability. That is how responsible are the company or the individual for what happened. And so all of those things we've spoken about will be considered. You know, how, what had you done? What had you not done? How negligent were you? How much did you turn a blind eye? And so all of those things will be considered in terms of an assessment of sentence. For companies, the size of the company is definitely important because the turnover is one of the relevant ways and features that the court will assess the level of a fine. But the role of the individuals, that's also really important. And so I can't underline more that if you occupy a role of any significance within your organisation, you need to understand the responsibilities that you have. And then next slide, please. So the range of sentences available, well, imprisonment at the worst. If it's a manslaughter offence, it's definitely prison. There is a recent trend, certainly in the past 4 or 5 manslaughter cases that I've been involved in, there is a trend towards increasingly higher sentences of imprisonment. The courts are taking it really seriously and they are imposing really long and big sentences. In Greenfeeds, it was two men that died. The director has received a sentence of 13 years imprisonment for their manslaughter. It's a big sentence. And in Recycling Cymru, so RCL Limited, a single death, the director has received 9 years imprisonment. So they are big sentences that will follow. Of course, if it's a Section 37 or Section 7 offence, then sentences of imprisonment are much less. They're restricted. It's a 2-year maximum for a Section 37 offence, but still prison is a real and realistic outcome to a prosecution. If it's not prison, it may be a community-based penalty with community service and or various requirements. A fine, certainly for a company, if it's a manslaughter, it can be in the terms of millions depending on the turnover of your company. And ancillary orders, there can be disqualification of directors if you are convicted of offences. Publicity orders for companies where you are required to tell the public that you've been convicted for the manslaughter of an employee. And so not only are you fined, but there is the reputational implications for what you've done. And compensation for the injured, for those that you've put at risk, or for the families who have been bereaved by the actions of the company. And so really sentencing is broad, it's meant to be punitive. And really my take home recently is that where in the past, prosecutions for health and safety may have, in some courts, received less by way of punishment because they weren't murders or robberies or stabbings or drug dealing. Experience is telling me that there is a shift away from that, and that these, our type of law, our type of industry, the law or the field of law that I work in, we are being met with ever increasingly higher sentences, both of imprisonment and levels of fines. And so it really is important. It was important before, but it's important more than ever now, that you really do everything that you possibly can to engage and to avoid getting yourself in a situation where there is any prosecution. And I think that brings me to the end of my presentation, Jenny. So if there are any questions, I'd be more than happy to take them.
Excellent. Thank you, Lucy, albeit absolutely terrifying. I'm sure a few of our delegates with manager in their name are thinking maybe I'll remove that. Doesn't necessarily remove the fact that you could be culpable in an offence. And it's not just whether something happens that is an injury or a death, it's the risk of that, I think, is a real take home as well. Even if it didn't happen, it could have done. And that's the prosecution's point. Okay, lovely. Thank you. Floor is open, please, if anybody would like to ask any questions of Lucy. I can see you, Gordon. You're the only person with your camera still on. Oh, here's John. Any questions from you, John Stevens?
No, nothing from me. It was all good to kind of go over and recap some stuff, really. Thank you.
Yeah. I think we always know how important it is, and then sometimes you kind of take your eye off the ball and you've got other operational challenges, and sometimes health and safety gets a little bit left on the wayside. And I think your presentation, Lucy, has helped to bring that back to the forefront of our minds. Okay, have you got off lightly here? Have we got no questions? I can't see any hands up.
So I should just say, if anybody thinks after the meeting, oh, I wish I'd asked the question, I didn't want to at the time, I'm more than happy, if there are loads of questions, to follow them up, Jenny. That's not a problem.
That's very kind. Thank you. Yeah, ask the expert. We'll offer that service as per Lucy's offer. Okay, well, if there are no questions, what we'll do, we'll take a short comfort break. It's just gone 10 to, so we'll come back at 5 to. Get yourselves a coffee, and then we'll move over to Matthew Lee, who's an ex HSC officer and now offers consultancy services and has a wealth of knowledge, practical tips to share with you. So I'll see you in just under 10 minutes at 5 to 3, please, if you can be back prompt. I'd be grateful. We'll see you in a moment. Okay, and we're back. So, without further ado, we're going to move on to Matthew Lee, who was an operational inspector at the HSE and undertook proactive inspections, reactive investigations and enforcement in a range of employment sectors, including manufacture, construction, fairgrounds, healthcare, research, agriculture and waste. He's also lectured to numerous audiences, as well as delivering training for those studying the NEBOSH certificate and diploma qualifications. After leaving the HSE after 36 years, well time served there, Matthew, he started his own independent health and safety consultancy, undertaking audits, investigating accidents and developing and delivering several formal and bespoke training packages for a range of organisations, including a number of waste companies. I also have the pleasure of sitting with Matthew on the SME group at the Waste Industry Safety and Health Forum. Some of you may know it as WISH for short. So Matthew, thank you for joining us today. I'll switch over to your slides. Here we go. Take it away. Thank you.
Thanks. Yeah. Okay. Next slide. So Lucy's given a really good overview of the sort of legal framework within which we have to manage health and safety. What I'm been asked to do is to go through sort of some of the more practical aspects to look at in the key areas. Okay, next slide. So first of all, we're going to look at the scale of the problem. The waste industry has a very, very difficult problem, track record. It's got a very poor track record, and therefore you're going to get lots of HSE involvement, and HSE involvement will concentrate on a number of issues. Slide down. Machinery, transport, explosive atmospheres, confined spaces, work at heights and contractors. And what I'm going to do is go through each of those in turn and give the key elements of how you should assess risk in each of these aspects of running a waste company. And then also finally where to get help. Okay, next slide. Right, so let's look at the accident stats. About 4,000 accidents a year. It's not a massive industry, but it has a very, very poor track record. Now, these figures are actually, I think, misleading because the accident stats are based on the employment sector that the employee was engaged with. So if you have a building contractor or a machinery maintenance company working on your site, and they have an accident, then it will not go down as a waste accident. It will go down as a construction accident or a machinery maintenance accident. It won't go down as a waste accident. So I think and a lot of the high risk activities we'll talk about later on is undertaken by contractors, but those figures will not be shown up in these figures here. But slips and trips on the same level. For that, we're looking at good standards of housekeeping, very basic stuff, but making sure that the surfaces that people are walking are good surfaces, they're not slippery with contamination, etc. And that's both the floor and things like steps. I'm not a great fan of some of the steps which have got these sort of tubular shaped surfaces on them. It's much better to have punch plate because that will give grip even if there's a reasonable amount of contamination, and making sure that the footwear that people are wearing is suitable. There's quite a significant difference of grip in different sorts of footwear. Injured while carrying out manual handling activities, 27%. Again, you need to look at where you're doing any manual handling activities, and if it's above certain weights, you need to very seriously consider, do we need to do this or should we use some sort of mechanical means? There's a very useful tool on the HSE's website called the MAC tool, Manual Handling Assessment Charts, which will allow people with very little knowledge about manual handling to carry out a reasonable assessment. And it's the sort of thing that HSE will look at. If you say, well, I've done we've had an accident with somebody in manual handling, and you say, well, we did a manual handling assessment based on the Mac tool, you're going to get a brownie point for that, that you were aware of that and you have at least had a go at it. Remember that accidents, when they actually look at them, they're trying to look at where you were at the before the accident, not necessarily where you were after the accident. So if you've done things afterwards, doesn't mean to say it was reasonable for you to do them beforehand. And then struck by moving objects, if you've got anything where you've got working above you, that's people or materials above you, you've got to think about that material coming off, and where people are working, where others are working above them. Okay, next slide. Now this is interesting because if you look here, we're looking at the two top figures. So we're saying 60% of all accidents, all fatal accidents, occurred in figures where the figures aren't big. If we went back to the previous slide, you'll see that moving vehicle and contract moving machinery doesn't appear on the top three items that cause accidents. So what this slide is saying to us is that there aren't a huge number of fatal accidents or a huge number of accidents involving struck by a moving vehicle or contact with moving machinery, but those that occur, there's a very high chance of them actually being a serious or fatal accident. So that's why the HSE will concentrate on those elements. And you can see there the figures at the top. Although the waste sector only accounts for 0.3% of the workforce, it accounts for 5.6% of the fatal accidents. So it's a worse accident rate than many other sectors, including construction. You know, people think of construction as being a very high risk activity, and but waste is significantly riskier in terms of numbers. If you're measuring risk by terms of number of accidents, than you will get it on the construction field. Okay, next slide. So we're now going to look at machinery. Machinery should be easy. Unlike many other aspects of health and safety, you should be able to guard a machine in many cases such that you can get a complete novice using that machine and they will be safe because you've designed the machine. It's fixed. You've got a design that you can live with. Now, machinery has caused a number of fatalities and serious accidents, and therefore the HSE are going to carry out 500 inspections between the 1st of October and the 31st of March this year to waste sites, concentrating primarily on machinery. They'll be looking at other things as well, but that's that their target is going to be based on machinery, and that's going to be looking at how well you're complying with the guidance, and we'll talk about the guidance at the end of the presentation, the guidance produced by WISH, because there's a whole new series of guidance. So if you haven't read the new guidance produced by WISH on machinery, then please have a look at it and make sure you've got that covered, because you will get, there's quite a high possibility of you getting an unannounced visit by the HSE, because most of them will be unannounced. They will just rock up and they will want to see risk assessments, they'll want to see conditions, they'll want to see training records, all those sorts of things. And you've got to put yourself in a defensible position. So the HSE will be looking at the WISH guidance, although it's not legal documents, they will be looking at that and saying that is what compliance looks like. And so you need to make sure that you've got those all in place. And that could be things like how you track conveyors. There should be no reason ever, you've got to track a conveyor with it moving, but there should be no reason whatsoever why you need to remove guards to tracking. You should design guards such as you can clean without removing the guards and without exposing people to access to dangerous parts of the machinery. And you've got to make sure that when you do things like unblocking hoppers, and it's mainly accidents occurring not during normal operation that are the majority of accidents, but the majority of accidents occur when people are maintaining, unblocking, unjamming, cleaning, those sorts of activities. And many risk assessments that I've looked at have not included those. They've looked at the normal operation of the machine and they haven't considered the high risk activities on that machine. So if you've got a trommel, how do you clean it? If you've got a conveyor, how do you track it? Those sorts of things that are maintenance activities or cleaning activities, you need to make sure your risk assessments consider adequately. And in many cases, this will require a permit to work. Permit to work can be key to operating a machine safely, as it can with other aspects we'll talk about later on, including confined spaces. But a permit to work is you are permitting work, and this is independently checking that the precautions you need in place, that could be locking off the machinery, that could be isolating certain parts, are in place. And this is an independent check. So rather than the person doing the work checking that the machine is adequately locked off, you get a second person to check that that machinery is adequately locked off, and that this is supported by adequate paperwork. And this is a paperwork based exercise. And what you need to do is make sure that people who are issuing permits to work understand that and have received adequate training. I'm dealing with an organisation, or a couple of organisations at the moment, where they've got permits to work in place, but when I've looked at the permits, actually they haven't been filled out correctly, and that is just a hostage to fortune if something goes wrong, because you can just ask questions as to why you answered the question. You can just ask why you answered the question in one way, and if you won't be able to get a satisfactory answer because there might be contradictory things within the documentation. So the new guidance issued by WISH, there's 5 new bits of guidance. First is waste guidance document 21 on lock-off procedures. Second one is waste 2033, which is machinery safety, a general guidance. And then there's some 3 information standards, 20 on conveyors, 21 on trommels, and 22 on balers. So if you have any of those, then you need to have a look at those information sheets, those guidance documents, and make sure you are complying with them. And what I would always recommend within the risk assessment documentation that you have, I know a lot of people like scoring, I'm not a fan of scoring. What I like within the risk assessment is you making reference to what documents you have considered when making that assessment. So if you've got a baling machine and you're doing a risk assessment of it, you put in that you have considered the matters in information sheet number 22 on baling machines when doing that. And therefore this does 2 things. It shows firstly that a proper check was made, because the people, if somebody's reviewing the risk assessment after an event, or even just reviewing a risk assessment, they can see the documents that are considered important when carrying out that risk assessment. So rather than you assessing risk, you're saying that the system, the process, says this is the control measures which are adequate. Okay, next slide, please. Transport. Transport's very difficult. Many serious and fatal accidents occur during transport, as we've seen from the previous figures. First of all, we have safe site. What you always need if you've got a site is to have a site plan to show where all the vehicles and people are going. Make sure that it's realistic, and it's realistic walkways, for instance. Often you get walkways which people will never use because they will always take the shortest route between A and B, and you've got to try and anticipate they're going to do that. Set realistic speed limits. One of my pet hates is 5-mile-an-hour speed limits. Nobody can drive at 5 miles an hour, realistically, and therefore don't set a standard which everybody's actually going to ignore. Where possible, have physical segregation between people and vehicles. The law just requires, which is the workplace regulations, just it says vehicles and pedestrians should be able to circulate in a safe manner. But that's all it says. There's no specific guidance other than that within the regulations under PURE. But there is some very, very detailed guidance that HSE had produced on HSG 136, and a really, really helpful checklist for workplace transport risk assessments. And if I ever, when I was an inspector, issued workplace transport risk assessment improvement notices, I would always just attach that schedule to the notice. I'd just attach that document and say, you need to consider all the relevant parts of this document. That document's about 5 pages long, but it goes through all the issues. So it feeds you, it allows you to go through the process. And if you've considered all those, then it may well be deemed that you've taken everything that's reasonable. Consider not just staff, but contractors and visitors. And if you're going to have a standard, then it makes sure that standard is enforced. So on many of your sites, you will have reverse parking. I remember going to a large quarrying company as an inspector and parking my vehicle. And when I went to reception, I rang to go into the building, and the receptionist said to me, "Have you reverse parked?" I looked back and there's only one car not reverse parked. Guilty as charged. And she said, "I'm sorry, you can't come in until you go and repark your vehicle." And it was quite clear. I go to another company that they've got a speed measuring device, and if you go, they've got a 15-mile-an-hour speed limit, and if you go above 18 miles an hour, it will pick you up. And if you're an employee, you get an email, and if you get 2 of those within a month, then you get banned from site. Somebody's lost volume. Is everybody else okay? Yeah, okay, so it must just log out and log in again, I think is the answer to that. So make sure that the contractors working on your site are aware of the standards, but they are realistic standards, and visitors, etc. In terms of driver training, make sure drivers are trained and fit to operate machines. That fitness can be temporary fitness, not being fit enough to drive. That could be they've got adequate hearing, adequate vision, adequate physical mobility. I investigated an accident with a forklift truck, and it turned out that the driver had been in the army and suffered serious back injuries, and he had problems turning round, and therefore he just used to rely on his mirrors when going backwards rather than being able to turn round. He was never going to be fit to drive, but that wasn't picked up because it wasn't one of the aspects that was looked at on the health surveillance. Make sure that if you've got contractors or other people, that they are competent. It's not just training, it's competence on the particular machine and the particular environment that you're working on. Make sure that simple stuff like key removal is undertaken so that you prevent unauthorized access to the machine to allow it to drive. Safe vehicles, make sure there's an effective maintenance program, but make sure also that if you do daily inspections, that those daily inspection checks are not over the top, otherwise they just won't be done in detail. You only need to do some basic checking of the vehicles on a daily basis. You may need to do more detailed checks on a less frequent basis, but daily checks shouldn't take you more than just maximum 5 minutes to actually undertake those daily checks. I was looking at one checklist for a forklift truck, and they were requiring every day for the thickness of the heel of the forks to be measured every single day, which is just complete nonsense. It wasn't being done. The forklift truck engineer told me that it would take him an hour and a half roughly to do all the checks that are on the checklist. That's going to be just counterproductive. Make sure it's pragmatic and realistic. And making sure that you've got the right vehicle for the job. So that's a safe vehicle. So it is the right particular bit of vehicle for the job. And then safe operations. Make sure that you consider all aspects of vehicle movements, e.g. refueling, moving in and out of buildings where you've got different lighting conditions. So when you go out of a building into daylight, then your eyes may not be able to be accustomed to the change in lighting levels. I investigated a fatality, not in a waste sector, but a school crossing patrol officer was killed because the driver involved couldn't see because they were dazzled by the sunlight, and it was a genuine problem at certain times of the day in certain weather conditions, that it was virtually impossible to see forwards, so that the safe operation didn't really consider that on that particular site you needed to make sure that the school crossing patrol officer was aware whether or not the driver had seen them before allowing children to cross. Okay, next slide. Explosive atmospheres. Right, so I think there's going to be more emphasis on this. I mean, obviously it applies to places like AD plants, etc. But there's going to be more emphasis on this because of the events that happened in Avonmouth. Now, the Avonmouth situation was that on the 3rd of December 2020, 4 people were on top of a silo. The press coverage indicates that somebody was undertaking some grinding, and there was an explosion. There was a contractor involved and 3 employees of the water treatment company. We still have not had, which is disappointing, I have to say, anything from the HSE. But note that that investigation is still going on, 3rd of December 2020. I know when Jenny talked about the green feeds fatalities, that I think that was about 5 years between the actual accident and getting to court. And people don't really appreciate how long all these things take to go through the process. So this is a specialist task, carrying out hot work, and there should have been a very, very, very clear permit to work for that, for hot work. And whether or not that was in place, I don't know, because all I'm going on is the press coverage. But there's no, or very, very little information being released by the HSE. I would assume that there was some methane gas within the silo, and that was what caused the explosion. That would be a logical way. There are some specific regulations, which Lucy mentioned, DSEAR, Dangerous Substances, Explosive Atmospheres regulations. The actual initial assessment on things like zoning of electrical equipment is a job for specialists. It's not a job that I could undertake, and many, other than the very largest of organisations, are unlikely to have people with the skills to be able to actually do that. Okay, next slide, please. Confined spaces. Confined space, any place which, due to the design of the space and any work being undertaken in it, causes risk. So if you have a normal office, that could be a confined space if certain work was being undertaken within it. So it's not just the space, it's what's going on within that space. There must be a comprehensive permit to work system for any work in confined space. It's one of the few things where, as with hot work, I suppose that's another one, where you would require a permit to work system. And it's easy because there are some specific regulations. Now, green feeds was where they were cleaning out a tanker which contained animal byproducts. Somebody was overcome by the fumes, and then somebody went in to rescue them. One of the last fatalities that I investigated before leaving HSE was a very, very similar situation, where on a farm, a gentleman went in just to do literally a 2-minute job, if not a 30-second job, actually, just to put one zip tie on a bit of kit within that confined space. He became overcome. His manager went in to rescue him. He also became overcome. The third guy on the surface was panicking at this stage, not unreasonably. The first guy actually managed to get out, but the second guy was completely overcome and fell into the bottom of the chamber, and actually died, having the post-mortem came back that he died being drowned in pig slurry, which isn't a way that I don't think any of us would want to go. But completely, utterly predictable, completely and utterly preventable. And what you've got is these code of regulations, which is absolutely fantastic, because this leads you through what a risk assessment confined spaces needs to be, including things like avoiding entry in the first place. Why are we going in, particularly with modern technology? If we're just going in to examine something, why can't we send in some sort of technology to look at what's going on inside? That would lead to us, if you do need to go in, there should be a safe system of work. There should be a safety supervisor. The people going into the space should be fit to be able to do that. They should be suitable. There should be adequate isolation of the confined space. It should be cleaned before people going in. You need to look at the size of the entrance to make sure people can get in and out, particularly if they're wearing breathing apparatus. There needs to be adequate ventilation that can either be sucking stale or contaminated air out or blowing fresh air in. And you need to test the air, and in many organisations or many waste sites I go around, you always have a gas monitor with you all the time, because there's all sorts of spaces which could, in certain circumstances, be deemed to be confined spaces. You may need special tools and lighting within that. There's been some explosions where there's been unprotected lighting in areas where there is flammable atmosphere, and special tools, that would be the grinding aspect that we talked about earlier. There may be situations, or I'm not a great fan of it, where you actually wear breathing apparatus. You've got to make sure that if you do have to wear breathing apparatus, that you've got enough people, they're adequately trained, the equipment is maintained, that sort of thing. There needs to be emergency harness, so if you've got a vertical confined space, that you can actually get people out of the confined space if they become overcome. There needs to be good communication between the people within the confined space and the people outside the confined space, and there needs to be very, very clear maintenance procedures. But the Greenfeeds prosecution was just a perfect example, and there's been many of those where it's not just the initial person that's in there, but it's those people that go in and rescue them that have also been overcome. And to be honest, within a confined space, you're usually either you're okay or you're dead. So there aren't a huge number of fatalities, but all the ones that are predictable and they are preventable. Next slide, please. Many of the fatal accident sector result in workers falling from height, particularly during maintenance and repair activities. A lot of the kit that we use on site now is big, it's tall, it's a long way up, and more importantly, it's a long way down. What you've got to do is identify work where work at height might occur and make sure that it's done in a safe manner. There is no legal limit to what working at height is. My low fall fatality was 22 inches. That's all he fell. He just is a 34-year-old guy. He fell doing some maintenance work on a bit of kit. He fell backwards, or was pushed backwards by the machine when it moved unexpectedly. Fell backwards, landed on the back of his head, and say he was only 22 inches up, but he died of a subdural hemorrhage 6 hours later. So you don't have to fall an awful long way. First of all, avoid it if you can, using mirrors if you want to look into hoppers or CCTV. If you've got to inspect roofs, nowadays lots of people use drones, which can be really useful. Have permanent platforms if you do need to regularly access or regularly view into a hopper or onto a bit of kit. And make sure there's safe access up there. So make sure there's a good ladder. You shouldn't be carrying stuff. You always should maintain 3 points of contact. There isn't any specific regulations about the use of ladders. The guidance is that ladders should be not used for more than 30 minutes in any one position, but obviously you get an awful lot of fixed ladders on waste sites. There will be times when harnesses should be used, and what you've got to make sure is that that harness is attached to something which is suitably maintained. The harnesses themselves should be inspected every 6 months, and the fixing point should be inspected every 12 months to make sure it's suitable. And you get various sorts of harnesses. You've got a fall prevention harness, which is so the lanyard is so short that you're not going to be able to fall. You get a fall arrest harness, which will stop you from falling, and that will often have a deceleration strap within the harness mechanism itself. But what you've got to be is high enough up so that deceleration part of the harness can actually deploy. Normally, if you're less than 5 meters, that's unusual. That's unlikely to happen because you need to slow down. If you fall even a couple of meters and then stop very quickly on a harness without, or a lanyard without any deceleration device, then that's going to do you a lot of damage. And then you've got to think about rescue. If you've got somebody, particularly somebody that's injured, and they're dangling on a lanyard, how are you going to get them down? You've got to think about that beforehand. I prosecuted the Environment Agency for exactly that issue. They had a guy and he was doing some tree surgery on some trees just outside Reading, and he fell. He was injured himself and fell. He was dangling. His feet were only 3 meters above the ground, but they'd got no way of getting him down. In fact, at the end of the day, they used the bucket of a loader shovel on a tractor they'd got on site to get up there to get him down, because they were about 3 fields away from a road. They ended up having to get the air ambulance in to rescue this guy out, and it was completely, they had got nobody trained in what's termed aerial rescue, nobody trained to actually climb up the tree to attach themselves on and then lower the casualty and themselves down to the ground. They hadn't thought about how they were going to rescue people. Make sure that people are trained to use ladders. Get an awful lot of falls from ladders. There's a recent prosecution that came through in the press a couple of days ago where somebody was trying to carry material up a ladder and therefore could not maintain 3 points of contact and fell, and the company will prosecute and fine a significant sum of money. Make sure the ladders are suitable for use and adequately maintained. Okay, next slide, please. Contractors, bane of many people's lives. There's a general misunderstanding. Can you scroll on, Jenny, please? There's a general misunderstanding that if work is undertaken by the contractor, then the owner has no legal responsibility. And all I can say to that is wrong, 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 wrong. I spend more time dealing with the management of contractors than anything else. And it is a major issue, not just within the waste sector, but in all sectors. They genuinely believe that there's problems, if the problem occurs, it's down to the contractor. In fact, I've just been involved in a recent fatality involving a contractor, and the contractor's company weren't prosecuted at all. The only people that prosecuted was the occupier. And the case to look at is actually health and safety, or not health and safety executive, it's a local authority case against Iceland, the freezer food company. They had got an air handling unit in one of their stores. The air handling unit had got a platform round it, but the platform wasn't very big and hadn't got a handrail on it. They allowed, and they knew that it wasn't very big and it hadn't got a handrail on it, and they identified it, but despite that, they allowed the contractor to go up and do the maintenance on the air handling unit. The contractor fell off, and although they only fell 3 meters through a false ceiling, they died of their injuries. And prosecution was taken against against Iceland, not against the contractor. And they fought that, and they said in court, and it's the Crown Court, 3-week Crown Court case, they said we should rely upon the contractor to make sure that their employees were safe. They argued that for 3 weeks in the Crown Court, and they lost the argument. They were fined £2.5 million for the death of that individual was contractor. And a considerable proportion of the serious and fatal accidents within the sector occur to contractors because they are doing many of the high risk and unusual activities. So and these may be additional labour, but they also can be maintenance of machines, etc., which can involve things like working at height, working where they've got to take the guards off machines. So you've got to make sure that they're adequately managed. You've got to make sure they're competent before they come into site. You've got to make sure that their risk assessments and the risk assessments produced by contractors vary enormously. Majority of them are rubbish, basically. They're one size fits all. You've got to make sure the risk assessment, because it's their duty as the employer, the primary duty rests with them to start off with, that the employer provides an adequate risk assessment. And looking at other people's risk assessments can be very, very challenging indeed. So it can be quite a problem area. And it's a wide range of activities that they cover. In some cases, they will be working under your risk assessments and your permit to work. And in many cases, permits are issued for the work of contractors. But it is one of the biggest issues of health and safety that many employers have. You basically got to be a proactive and intelligent customer, and you've got to put yourself in a position where something goes wrong, you can say it went wrong, but despite all that, this is what I did. So recording your review of risk assessments, recording any monitoring activities. I was recently at a site where a contractor was working on some electrical equipment. The permit to work issued by the occupier said that all the electrical equipment had been isolated. So I said, well, let's go and have a look at the isolation board to see if it was not just isolated, but locked off. And in fact, all the occupier had done was actually switch the isolators off. So there's nothing to stop somebody just flicking the switch, and instantly you'd get all the contractors working on equipment which they thought be dead, but actually was live. Okay. Remember, they may not be familiar with your site. Okay, right, where to get help. Okay, next slide, Jenny. Right. As Lucy mentioned, there's some really great information on the HSC's website via the WISH sort of portal, as it were. They come in 3 basic forms. There's information sheets and there's guidance documents. Don't worry about why some are called guidance, some are called information sheets, but there's a huge range of information there, and they will be used as what compliance looks like. So you need to look at that list. Just go onto HSE's website, put in WISH guidance and WISH information sheets and look at those. There's 18 of them each. And they will allow you to go through your risk assessments to decide whether or not what you've done is adequate. So that's the starting point. The third one is there's a summary of occupational health hazards with links to further information. That's 7 pages long, which is again a very helpful sort of document. Okay, so those are the WISH guidance, and if nothing else, if you go away today taking the WISH guidance and looking at it and considering how it applies to your organisation, then hopefully you'll identify any shortcomings, etc. The other document, which is very helpful, which isn't easily, it's there, but it doesn't come up when you put in machinery guarding, is actually designed for it's called safe intervention. So if you put in HSE safe interventions, you will get the best checklist for machinery guarding that I am aware of. It's a fantastic document. It's about 5 pages long, but it goes through all the issues. It's written primarily for the paper sector, but don't worry about that. It's a really helpful document. So if you've got machinery that you use on site, just put in HSE safe interventions, download that, and then use that as a risk assessment. And again, make reference to that within your risk assessment documentation. Okay, that's all I've got to say. So next slide, any questions on anything which I've covered or any other health and safety issues?
Excellent. Thank you, Matthew. What a great presentation. Very insightful, very helpful, useful, simple but effective tips. Any questions? Floor is open. Any questions for Matthew? Yes, come in, Jack.
Hi guys.
Hello, Jack.
I'll just remove my hand. Yeah, I just had a question regarding the incident you made reference to earlier with the gentleman that was a veteran and couldn't turn his back.
Yeah.
When he was on the machine. I just wondered how you dealt with that, because that would have been obviously a pre-existing employee already undertaking a task.
Yes, it was a large employer, but their occupational health questionnaire didn't really pick up adequately questions about mobility. And in fact, after the event, it was decided that he was no longer fit to be a forklift truck driver.
Oh, okay. And then,
so he went on to some other role, but there's no way he could be a forklift truck driver, because he could move round to the side, but he found that very painful, and therefore just didn't, and therefore relied upon his wing mirrors. And of course, what happened was he reversed backwards, and there was a vehicle coming from the side of him which wasn't picked up on the wing mirror, and he actually reversed into the vehicle, another vehicle behind him, another forklift truck. And although the guy wasn't knocked off the forklift truck, he suffered 2 fractured ribs. That's how hard he hit him. And he bent the body of the forklift truck, which are sort of 25 millimeters of steel. He bent that by about 30 millimeters. That's how hard he really did whack it hard. He claimed the windows to the forklift truck he was driving weren't cleaned, which could have been an aspect, but primarily he just couldn't turn around easily. Yeah,
okay. So yes, what I was going to ask for advice on them, and you've answered it there, was through the occupational health position, really. But even in that example, where it was, did you say it wasn't picked up in that initial stage with the paperwork? Did you say? Yeah, it wasn't. Yeah. So what I was going to ask is, if a situation like that arose again, where it wasn't identified initially at employment stage, and then just through observation and supervision it was identified, would you then advise, speaking to that, engaging with that employee and seeking that occupational health advice, and then going down that route?
If you've got queries about because obviously people's health will change from time to time. Sometimes you might have a temporary injury that will fix itself. Other times, I can remember going round with an occupational health nurse, actually, a food company, and she was doing some eyesight checks on drivers as part of our occupational health checks. And she went to the managers after doing one guy and just said, "You've got to take him off, until he goes and gets himself some glasses. I am not you know, he's not fit to drive. End of, really.
Yeah.
You know, it's difficult because sometimes there may not be alternative employment, you know, not suitable employment. In this case, there were a large company, they managed to find him a different job. But in some cases, I'm sorry, you're not fit to work, you're not fit to work, and you've got to be made redundant on, you know, it's an employment law issue. But if you're not fit to work and there isn't any reasonable adjustment your employer can make, then I'm sorry, you can't carry on working. You can't, if there aren't reasonable adjustments that your employer can make.
That was the little bit that made me twitch a little bit when you mentioned it earlier, was the whole sort of like constructive dismissal potential element over it. That, you know,
yes, you've got to,
you decided to leave by his own
I
accord.
mean, I'm not an employment law expert, but at the end of the day, if somebody isn't fit, then they're not fit. You can't allow them just because.
Can't compromise safety. Yeah.
You can't compromise safety. No.
Okay. All right. Thank you, Matthew.
Okay.
Cheers.
Thanks, Jack. Interestingly, news just in on Let's Recycle, a refuse collection vehicle case involving an employee who was dismissed. Just trying to quickly read the facts, where he's kind of gone on the rave plate at the back of the vehicle to clear the camera, and his employer, which was Leicestershire District Council, dismissed him for that conduct, and he challenged that dismissal, and it's just been upheld literally in the court today, that it was unfair dismissal, and it was because of the shortcomings of his employer in making sure that these kind of shortcuts, bypasses weren't actively done by employees.
Yes,
so
you've
that
got to
interface with employment law as well, as you say.
It is, yes. Now, I'm not an employment law expert. It's like sort of when you introduce smoking bans and things like that, you know, you've got to go through the correct process, which is where you need to get specialist HR advice.
Yeah, definitely. Come in, Hannah.
Hi, Matthew. I just thought I'd ask, obviously Aidan mentioned earlier, we are contractors in the waste industry, but also beyond that as well. And there is, like sort of Lucy touched on earlier, a great deal of risks that, you know, we are presented with, and that leads to a great deal of documentation. And whilst we do, you know, a lot with employee engagement, I wonder if you have any advice on how we can ensure documentation doesn't become white noise due to the sheer amount of it.
Right. Documentation, in my view, comes in two forms. You get a sort of generic assessment of the task that you're doing. So if you're using a ladder, it doesn't matter where you're using a ladder, you're using a ladder. So things like the maintenance of the ladder, the angle the ladder should be, that's maintaining 3 points of contact will be standard. Therefore, your generic risk assessment will be suitable. However, you then need to look at where that ladder has been used on that particular site, and they need to be site specific. So if, for instance, the ladder's being positioned where it's likely to be knocked by a vehicle or being used by, again, near some overhead power lines, then you need to have generic plus. And what I mean, I've looked at risk assessment. I look at so many contractors' risk assessments, and some of them are 40 and 50 pages long. You might as well just forget them, because nobody's going to read them. They need to be short, succinct, but pragmatic, rather than too long. A lot of people also say I'm not a fan of scoring systems, because scoring is on likelihood and severity. And severity, I think we could all have a reasonable, consistent approach to. If you're going to fall 5 meters, it's going to hurt, and it's going to hurt a lot. But the chance of you falling 5 meters will depend very much on your perception of risk. So I'm not a fan of scoring. But what I ask occupiers to do is to look at contractors' risk assessments, make sure they have some site-specific element in them, and appear to be reasonably covering the job in hand. But it is a very difficult issue. And I say, I mean, I've worked with many organisations. I think I do more work with this than anything else. And I've come up with, you know, I've got lots of contractor policies that, I mean, if you email me and I'll send you one that I think is about as good as it gets in terms of management of contractor policy. But it's not easy at all. And that's, I don't know what percentage. I don't think the HSE they haven't really got to grips with contractors. There's managing contractors document, And there's a very useful IOSH document on managing contractors, which is about procurement of contractors, making sure they are competent. I mean, what is competence? You know, it's a combination of skills, knowledge, training, attitude and experience. But it's very difficult as an occupier to say, is the contractor that rocks up on a Monday morning at 9 o'clock competent? How do you make that assessment? Very, very difficult indeed. And in many cases, contractors' role in life is to do the job as quickly as possible, extract as much money from you as possible, and disappear disappear. And therefore, if the shortcuts to be taken, then they may be taken. So you need to monitor their work. If you're an occupier, you need to monitor the work. If you're a contractor yourself, you need to make sure you've got the competence of people, but also then you do monitor how well your staff on various people's sites are working in a satisfactory manner. But it is a massive issue. Let's say that there's the HSE document on managing contractors, which is very useful. It's a very heavyweight document, but it's a useful document, and it's the one that will be used by the HSE as a sort of a benchmark standard as to how you manage contractors. But it's not easy.
Yeah, and I think it's, you know, as much for contractors as it is for staff as well, trying to make sure that staff are actively engaged in the documentation and they've had their say and they understand it, and that they've had an opportunity to put their point across as well. They're much more likely to want to use it and implement it.
Yeah, this goes back to actually risk assessments. Risk assessments should not be done by managers in isolation. Risk assessments should be done by the people undertaking the work, because they will know how it's actually done, and it should reflect how it's actually done, not how you think as a manager it should be done or is done, because you're not there all the time. And if you make it difficult, like the reverse parking thing, you know, if you're quite clear about what the standard is, and then you enforce that standard. But if you don't involve the people who are doing the work, then they're likely to find shortcuts, etc., which to them might seem satisfactory, but in reality are not satisfactory, because they're not perhaps aware of some of the risks that are actually there.
Yeah, I think the difficulty, I mean, the likes of Blue, it's large, reputable organisation and a proactive attitude to health and safety, and you've done everything you can your end, and with your staff and with your training, everything that goes into that, and then they go onto a site where perhaps health and safety is not being a priority, and it's putting them into that risk environment, and trying to get those operators of those sites to really step up to the mark and make sure that your contractors are safe whilst out and doing their jobs.
And one of the other issues can be that you, as an occupier, you haven't got a choice of contractors, because if you're having a machine maintained, the only people that often you can get to do the maintenance are the suppliers. And if the suppliers of the machine don't have good standards, then that can be very difficult, because at the end of the day, if they're just normal contractors, if they're roofing contractors, for instance, you can just chuck them off site and get another roofing contractor. If they're maintaining the machines, the only people who can maintain them is that contractor. So you haven't got the lever of chucking them off site that you would do in other cases. Yeah,
that's very true. I find a lot with our members, with clients that I've dealt with, certainly the smaller waste recycling operators, is that they may well have very good procedures, but they're not very well documented. Yeah. And then as a lawyer, obviously it's all about paperwork, it's all about evidence, and it's paperwork that's not collecting dust on a shelf, it's actively implemented in practice and adhered to. So I think just, you know, tightening up those systems and procedures and making sure there's a clear audit trail, which can't emphasize enough. That may be literally your get out of jail card.
If you've got procedures in place and you can demonstrate you took reasonable steps to maintain those procedures, then you're in a defensible position. If you haven't got those procedures in place, or you've got the procedures, and it can be even worse, if you know there's a problem, like with Iceland, they knew there was a problem with the platform, and despite that, they allowed the contractor to work on that platform. And therefore they could
blindness.
They knew the risk was there and they chose to ignore it. I'm at the NEC next week for a couple of days, so for both days on the Wish stand. So if people want are going to the show and want to stop over and have a chat, then I'm very happy to give advice and guidance on a one-to-one basis.
Oh, thank you, Matthew. The mainstay of my work is defending Environment Agency prosecutions against waste operators. So it was quite refreshing to hear that they also can be prosecuted as you did in your practice, Matthew. They're not.
Yes, because they're actually the biggest tree surgery company in the UK. And when we went through their procedures, it was woefully inadequate. Let me put it like that. And that's why they were prosecuted.
Shocking. Okay, any more questions for Matthew? Right, well, they have been two absolutely intriguing presentations. Can't thank you enough, Matthew and Lucy. Once again, can't thank Blue enough for their support and sponsorship to bring this event to you free. And I hope that it has been useful. As I say, those the video will be downloadable if you want to share it with colleagues and within your network. For those that have been able to attend today, we will send a certificate of attendance, an electronic version, so it can go on your CPD file, which hopefully will be helpful. UROC, myself, my team will be at the RWM show next week, so I hope to catch up with some of you there. And you know where we are if you need us. The door is always open. And without anything further to say, unless Hannah, you want to do any closing, Aidan may still be around to say goodbye.
We're both still here. Yeah, no, thank you for everyone for attending, and thanks for Lucy and Matthew presenting today. I think it was really, really insightful, and I'm sure that everybody's got something they've taken away from that.
Thanks, Jenny. Thank you, guys.
We'll also have the slides available for you as well. We'll circulate them on the email. So until we see each other again, thank you, take care and be safe. All the best.
Okay.
Bye-bye.
Thank you.
Bye now.
Bye-bye.
Cheers.
Bye-bye.
Thank you.
Bye.
Bye.
Good.